Hi, Sam, and hi, Christine. It is great to talk to you today about an important topic that continues to be an important part of our practice, the hashtag #MeToo movement and its impact in the workplace. A little more than 5 years ago, the world finally gained some insight into the extent of transgressive behavior and the damage it can cause to people, businesses, and industries worldwide. The impact was felt in the United States and far beyond, and the hashtag #MeToo movement brought a shockwave and made an ever-persistent issue tangible. It encouraged victims and bystanders to speak up. It encouraged employers to take action by investigating allegations and taking appropriate measures if certain allegations were found truthful. And that was also the case in Belgium. For instance, in Flanders, we had our own equivalent of the Weinstein saga when a well-known TV producer was accused of transgressive behavior by several actresses with whom he had previously worked. He was found guilty in the fall of 2021 of stalking 5 women and having caused nuisance to 1 woman through electronic communication, and a reprieved prison sentence of 6 months was imposed. Another example is a well-known Belgian artist and choreographer who was accused of sexual harassment by 20 former employees, and he was eventually sentenced with a reprieved prison sentence of 18 months. It is clear that the hashtag #MeToo movement put things in motion from a societal perspective. And today, 5 years down the line, we're wondering what the changes are on the legal landscape. So Sam, how have things been developing in the UK?
Thanks, Cato. Following various promises made by our government in 2021, there is currently a bill progressing through Parliament on the prevention of harassment, which would reintroduce the employer's liability for third-party harassment. And impose a duty on employers to take all reasonable steps to prevent sexual harassment in the workplace. So it's really important for employers to take note of this and do more than simply writing a policy, as the bill proposes to give employment tribunals the power to uplift sexual harassment compensation by up to 25% for any employer breach. So compensation for harassment claims is already uncapped, and this is going to be very costly. There's also been some unrest following a last-minute amendment to carve out free speech, and that means that employers wouldn't be liable for the expression of certain opinions by others in the workplace, and that's going to create a grey area. It's great work for lawyers, but not for the employees or even the employers. Something that I've noticed initially was this sort of knee-jerk panic reaction by some employers to Me Too type grievances, and almost a kind of, you're dismissed unless you can show otherwise approach towards the alleged perpetrator. Obviously, there's a duty of care owed to both sides, and I think employers are becoming much better at investigating complaints and following a fair process for all involved. Not just that, but also encouraging people to come forward without fear of retaliation. And finally, there's also been a shift away from the use of all-encompassing NDAs, not least that there's been action taken against lawyers involved in the drafting of inappropriate gagging clauses. Increasingly, employers are taking the view that open disclosure is better, not just reputationally, but also for employee relations. So I think in summary, from the UK's perspective, we've made some inroads, but there's still quite some way to go.
It's very interesting. Thank you, Sam. And how about Norway, Christine?
Well, the focus here is still pretty much on Me Too within the work life, and I think it will continue for years to come as well. The employer must lead and arrange the work so that no employee is exposed to harassment in the context of work. There is a general reference to this obligation in the Norwegian Employment Act, and in addition, there is a special act for equality and discrimination, which defines sexual harassment. We do not, as per today, have a definition of sexual harassment in the employment law, but this is coming now, actually, because in order to highlight the fact that the Protection Against Harassment in the Working Environment Act also provides protection against sexual harassment, the government will strengthen work against harassment in working life by defining sexual harassment also in the Employment Act. And the process on this is ongoing as we speak, actually. And we had the Supreme Court decision back in 2021, which has had an impact on the focus on sexual harassment. But unfortunately, this also shows that the compensation level for being exposed to sexual harassment in Norway is rather low. We do not have any American conditions with regard to the compensation level here. And from 2020, there has been a possibility to send a free complaint about sexual harassment for employees to the Public Discrimination Board. And then you can demand compensation and restitution up to Norwegian crowns of 80,000. This makes it easier for employees to forward complaints in relation to this, and we have seen an increase actually in such complaints. And as a lawyer, I also have seen that employers clearly has a focus on this topic, and the threshold for obtaining legal assistance in this type of cases are rather low actually.
Thank you, Christine. I think there are similar trends in Belgium. We have seen some changes too since 2017. So for instance, in 2019, the Flemish Ombud Service received a very specific assignment that was linked to the gender chamber following the #MeToo movement in order to help look for answers to questions that have arisen as a result of the #MeToo movement. The service is competent to receive complaints and can initiate mediation or contact organizations and companies where transgressive behavior has taken place. And there's a steady increase in the number of complaints received. So for instance, in 2021, they received 50 complaints on the topic, and in September 2022, already a number of 120 complaints. The second change that we've seen is a sexual criminal law reform. Taking into account the fact that victims often do not dare to report the crime, it is estimated that 80 rapes per day are committed in Belgium. And in order to better address sexual crimes, Belgian sexual criminal law was reformed on the 1st of June of 2022. The guiding principle of the reform is clearly that non-consensual sexual acts should be able to be severely punished, and the need for consent is given a central place. Sexual offences were given new definitions and in some cases are more severely punished. And then lastly, Belgian high courts are also joining in on the trend. The Court of Cassation ruled that the intentions behind certain behavior do not qualify as a constitutive component of the crime of transgressive conduct in the workplace. Unwanted conduct is sufficient regardless of the alleged good intentions of the perpetrator. And then secondly, the Constitutional Court ruled that the Belgian Workers' Welfare Act should be read as allowing not only labour courts, but also criminal courts to award lump sum compensation to victims of an act of violence at work. The court points out that this was indeed the legislator's desire to lighten the burden of proof for the victim, to reduce the number of disputes on financial compensation, and to create a deterrent effect vis-à-vis the perpetrators of such acts. So I guess a lot has changed and will continue to change. Thank you both for these interesting insights. I'm sure we will hear more about this in the years to come, and we will of course continue to monitor these changes together.